So thanks for joining us, everyone, for our presentation on wills and trusts, how to avoid the three biggest mistakes that we see. And I'm excited to share these with you and for you guys to learn a lot today in our presentation. I'm joined by Jessica Ramirez. I'm Pamela Hailey-Petty. We're two of the three attorneys with the Hailey-Petty law firm. I'm in Austin and Jessica is in San Antonio. A little bit about us. I started the firm in 2013. Jessica joined me in 2018. Between the two offices, we have 3 attorneys and 4 paralegals and assistants. And we practice in Travis, Williamson, Bear, and some of the surrounding counties. So what we're going to talk about today is what is Texas probate and why you may want to avoid it. And then, of course, the 3 biggest mistakes that we see and how to avoid those. And then what does planning for success through estate planning look like? And then your exclusive offer for joining us today. So first, what is probate? So if someone has passed away, and the probate process is really administering the estate, gathering all of the assets in the estate, notifying any creditors. And so part of that, more often than not, is through some sort of court procedure, where if the person that passed away has a will, we apply to get the will admitted to the court so that it has effect, and getting a personal representative who is either the executor or the administrator appointed by the court to have authority to act on behalf of the estate. So to do all of those gathering of assets, notifying creditors, and ultimately distributing assets of the estate. It's important to note that only probate assets will be under the control of that executor or administrator. So we'll get into this a little bit later, but there are probate assets, which they have control of, go through the probate process, and then there's no non-probate assets that are covered outside of the estate. And so what happens to property when you die? So if it's a probate asset, a house, a titled vehicle, any financial accounts that don't have beneficiary designations on them, then your beneficiaries in your will or your heirs at law, if you don't have a will, ultimately receive that property after the administration of the estate. But that court procedure does need to happen. And if you have financial accounts where there are designated beneficiaries, then the people that you've designated as beneficiary on those accounts will receive those properties outright. So outside of the probate process, your executor or administrator, that personal representative, will have no control over those assets. If there's jointly owned property and there are rights of survivorship between the joint owners, then that is also a non-probate asset. So when one of the joint owners passes away, then the other joint owner or joint owners have full ownership of that property without the need for it to go through probate. So that's also that non-probate asset. And not having a will, right? So no planning in place leads to the state of Texas intestacy laws deciding how your assets are going to be distributed. And this is called dying intestate when you have no will.
So let's talk about what is so bad about probate. And basically, to sum it up, your family has no control. So it can be expensive, it can be very time consuming, it can take 9 months to 2 years. With COVID, we've seen this time increased. And in addition to that, it's public. So whenever we file for probate, we have to file an inventory with the court. And basically, everyone can see what the assets are of the decedent, in addition to what the beneficiaries of the will be receiving, or even if there's not a will, the assets that pass to the heirs at law will be public record. And then wills always become susceptible to contests whenever a probate estate is open.
Yeah, so Jessica, I don't know if you hear this from your estate planning clients. You know, when we go through estate planning, a lot of times they'll ask, okay, now what do I do? Or what do I do when my spouse passes away? And we give them an overview of the probate process, and their response sometimes is, oh, wait, so I'm going to have to do something with this will once someone passes away. I don't automatically have control to go and, you know, take control of the assets. And so the fact that you have to file the will for probate, and then the court has to appoint you before the surviving spouse even has any control over the estate and the estate assets is a surprise to a lot of people. So
For sure.
Yeah.
And in addition to that there's a 4-year rule, right? So you have 4 years to probate a will. And if you do not probate within those 4 years, you have to provide a valid reason to the court for not probating. So
Mhm.
I'm sure you see that too a lot, you know, that people come in and I didn't know I had to probate, and most people don't.
For sure. Yeah. And then you have to notify heirs of attempting to probate at that time. Yeah. It can get more costly and time consuming. So yeah, that's definitely something that we see.
Let's talk about the 3 biggest mistakes that you can that you want to avoid, right? So, not having a will or having a properly drafted will in place is number 1. And then problems with joint ownership and property. So, people assume if they are joint owners that the joint account holder or the other person that is titled on the house automatically receives that property. We will see that that's not always true. And then the lack of or incorrect beneficiary designations. So we're going to talk a lot about beneficiary designations and how we can use those to help us at our estate planning achieve our estate planning goals. So first, let's look at mistake number 1, not having a will or having a properly drafted will. So as Pam mentioned earlier, when you pass away without a will, this is called dying intestate. And when you don't leave instructions in a will for how to distribute your assets, basically the state of Texas determines for you. And the property will get distributed through intestate law. And so one of the biggest misconceptions that I have come across is when people assume that when they pass away, all of their property will automatically go to their spouse, or it will automatically pass to their living children. And this is not always true. So, for example, if we have a married couple, the husband has children from a previous marriage, and the couple buys a home together during their marriage, so it's community property, and then the husband passes without a will, even though his interest in the home is community property, the law states that half of his 1/2 community property interest will pass to his children from his previous marriage. So now his wife is left owning their home with his kids from a prior relationship. And this is definitely one of the biggest probate headaches that come across my desk. I'm sure you see this too, Pam. The step parent owning property with the stepchildren. It's always a mess. People end up bitter. It ends up costing a lot of money in attorney fees to reach a settlement agreement. So this is something, you know, that definitely can be avoided by just doing a will. Just get your will drafted and save everybody a lot of stress and fighting.
Mm-hmm.
Another misconception, parents assuming that their property passes to their living children. So if you have a child that predeceased you and you pass away without a will, that predeceased child's heirs will inherit that share. So this means that your child's share will pass to their own children, your grandchildren, or even further down the line. And this may be what you want to happen, but it may not, especially if these grandchildren are minors. So, in that scenario, young children can inherit a large sum of money, and that's always something we want to avoid. And by setting up a proper will, we can help you do that. And finally, drafting a will yourself or an online will template will help you save money. This is a misconception that I see that ends up costing my clients so much money. In fact, I think one of the most expensive probate matters that I have worked on has involved a holographic will, so a will that was drafted by the decedent themselves and not by an attorney. The will templates on the internet, they don't conform to Texas state law. They're usually missing information that enables the executor to act independently from the court. And ultimately, much more money is spent in the long run trying to clarify the terms of the will and understand the testator's intent. So we always recommend, of course, that you have a will drafted by an attorney.
And then, of course, the misconception of I don't have significant enough assets to need a will. Most people have property that necessitates having a will to make probate easier for your loved ones. In other states, for example, the house may pass to your spouse without the need for probate, but that's not the case here in Texas. And so oftentimes it is just the house that we're dealing with in probate, or one bank account that doesn't have a beneficiary designation. So even if it's a small amount of money or just one asset, sometimes it necessitates a full probate. So you really want to have all of your documents lined up for that as well. All right. And mistake number 2, so problems with joint ownership and property. The misconception here that I just covered is my spouse will receive my half of the house because we own it jointly. Like I mentioned, other states that is correct, but in Texas, you need to clear your deceased spouse's interest in the house to make sure that it passes to you. Sometimes that's easily done without a will, and sometimes, in the situation where your spouse had children from outside the marriage, then that can be more difficult and costly, like Jessica mentioned. And then my will controls distribution of all of my assets, even jointly owned financial accounts held with one of my children. So that is not necessarily the case. So if you have a joint financial account with another person, then that may have rights of survivorship on that account, and oftentimes it does. And so when you pass away, it doesn't matter what your will states, the property would pass to the other joint owner regardless. And so you need to be very clear and intentional with those people that you own property jointly with, and how you designate, your power of attorney and beneficiary designation. I feel like I need to do that one again.
Okay. I'm going to just start over.
Yeah, I'm just going to start with mistake number 2.
Okay.
Okay. So mistake number 2 that we have is problems with joint ownership and property. So the misconception, again, that my spouse will receive my half of the house because we own it jointly. And just like I stated previously, in other states that is the case, but in Texas, we do not have automatic rights of survivorship on real property. So if your spouse predeceases you, you do need to transfer that spouse's interest to you after they pass away. And so sometimes that can be easily done without a will, and sometimes it's more difficult, just as in the case where your spouse had children from a prior marriage, then that may be much more difficult and costly to do. Another misconception is that my will controls the distribution of all of my assets, including any jointly owned financial accounts. And that oftentimes is not the case. So the financial accounts may be held, and oftentimes are held, as joint with rights of survivorship, meaning when one of the joint owners passes away, then the surviving joint owner receives all of the property. And so regardless of what your will states, that joint owner will receive 100% of that property. And so you just need to be very intentional with the people that you own jointly owned assets with, whether those that property has rights of survivorship on it, and then of course any beneficiary designations.
And Pam, this sorry, I didn't mean to interrupt you, but this scenario I actually see a lot too is a parent owns a joint account with a child and they rely on that child. It's normally a child that lives close to them and helps them pay their bills, takes them to medical appointments. They've put this child on this account to help them out. And a lot of times that is their only account. And so upon passing, that account then is passing to this one child. All of the other children are left out, and that child has no obligation to distribute any of that money. And a lot of times they feel like they've been the child that has been taking care of mom and dad, or taking them to those appointments, and it can definitely lead to conflict. So
yeah, and they definitely feel entitled a lot of times, like you talk about. And that may or may not be your intention. It's fine if it is, of course, but just that getting clear about what your intention with that property is. So we'll go through this example. So Phyllis is a widow. She wants all of her assets to pass equally to her 3 children. We create a will that says this, and she signs it. And then Phyllis titles her bank accounts with her granddaughter, Cindy, because she wants Cindy to be able to pay all of her bills if Phyllis loses the ability to do so for herself. And like Jessica said, this is a very common scenario. So then Phyllis dies. Phyllis's bank accounts are now owned by Cindy because they had rights of survivorship on them. And that's not what Phyllis wanted. Phyllis didn't realize that is what that meant, because oftentimes what will happen is that is in the the fine print when you go to open a bank account and you don't read it. The banker doesn't explain that to you. And so, Phyllis's wishes aren't filled, right? It all goes to the granddaughter, when in fact, what Phyllis needed was a statutory durable power of attorney to give Cindy the ability to manage those bank accounts and pay her bills on her behalf with her money. And so that would be a better way of accomplishing that goal.
Okay, so mistake number 3, this is the lack of or incorrect beneficiary designations. So, Pam, today, when I was reviewing our notes, thought about yesterday. I actually had a client come into my office, and she has 7 children, and she had listed one of these 7 children as the beneficiary behind her husband on all of her financial accounts, every single account, retirement, investment. She had a life insurance policy. And she told me that because that child will be the executor of her will, she listed her as the alternate beneficiary so that she can distribute all of the money equally to the other 6 children. And when I explained to her that whenever you have a beneficiary listed on an account, a financial account, that money upon death will pass automatically to the beneficiary listed. So if your husband has predeceased you and your daughter receives all of that money, she has no obligation to distribute any of that money to any of the other children. And she was shocked to find out
Mm-hmm.
that, this was the case, and it made her nervous. And so at that point, we started talking about, better ways to handle this situation. How can we use those beneficiary designations to achieve the goal that you want, which is all of your children inheriting in equal shares without a fight, right? So
Mm-hmm.
it's really important that you speak to an attorney. Make sure that your estate plan is designed to reflect your wishes. Make sure your beneficiary designations enable you to distribute your assets how you want. And there are many different options that we can look at to make sure that these goals are met, and to avoid conflict in your family. It's also important to know that your will does not control money in these financial accounts that have beneficiary designations. So if you have a beneficiary designation listed, that money upon your death will pass automatically to that person outside of the will and outside of probate. Okay. Minors, this is another issue that we see a lot with beneficiary designations. Listing a minor child. So, say for example, that you have a $100,000 life insurance policy and you leave it to your only child, who at the time is a minor. You pass away before they turn 18. That money is held in a custodial account until that child reaches the age of 18. So, upon reaching 18, this child inherits whatever money is left in that account. So let's assume that it's the full $100,000 life insurance policy. You have an 18-year-old child inheriting $100,000. And obviously, this could be detrimental. They can blow through it. You want to make sure that you avoid the scenario by drafting proper estate planning documents. And then, of course, updating your designations. So we can use beneficiary designations as a tool in estate planning when trying to avoid probate, as we've talked about, but this can backfire if you don't keep them updated. So let's look at an example. So we have Bob and Mary. They have a $100,000 life insurance policy, and they've designated each other as beneficiary. They don't have wills, and they don't have any alternate beneficiaries designated. Bob dies first, and Mary is the beneficiary of his policy. So great, Mary receives his policy funds, all is good. Mary passes away years later. She never updated her beneficiary designation. It still had Bob's name, her husband. So because Bob predeceased her, that asset is going to pass through probate. So Bob and Mary's children are going to be forced to go through an intestate probate procedure. It will be the only way that they can collect the money from that account unless they let it sit and get turned over to the estate. And so a lot of times, when there are funds left over in these accounts because of incorrect beneficiary designations, the funds may not be enough to make it worthwhile to go through an intestate probate procedure. It's very expensive. It's very time consuming. And this is definitely a situation that you want to avoid by just getting proper estate planning done with your attorney, um, letting an attorney help you get your affairs in order and make sure that those designations work to benefit you and not harm you in the end. Okay, let's talk about, oh, this is you, Pam.
Yeah. Planning for success. So how do we avoid these situations? First,
I think
we'll
you
talk
need
about.
sorry, wait, Pam, I think you need to, you're on joint ownership of property, right?
Mine says planning for success.
Oh, how to plan for success, joint ownership in real property. Yeah, you're right.
Yeah. Okay.
So maybe start over on that point.
Yeah.
Sorry.
No worries. I'm just going to make a note of which one we stopped on. All right. Okay. Thanks, Jessica. So now we'll talk about planning for success and what is estate planning, first of all. It's a combination, some combination of several of these things. So it's beneficiary designations, which we covered, getting those done correctly and coordinating those with your wills and your trusts to make sure that overall your estate is being distributed the way that you would like. Rights of survivorship, they can be good, but again, you just want to be intentional about when and how they're used. And then deeds, there's revocable transfer on death deeds, which we'll cover in just a little bit, ladybird deeds, and then just transfer deeds if we're doing trust planning, just, good old transfer deed where you transfer property that you own now during your lifetime to a trust that you set up now. And then, of course, wills, where you can designate who you want to act as executor, who your beneficiaries are, what powers you want to give to the executor, any specific distributions, if any, that you have. And of course, that is only going to control property in the estate, right? Only those probate assets at your death. Whereas trust, you can utilize to act both to distribute assets when you passed away, but also to handle assets for you and perhaps for your children, any dependents that you have during your lifetime. So that if something happens to you and or your spouse, someone can step in, your named successor or your spouse, and handle all of the assets in the trust on your behalf. And if you have dependent children, for example, perhaps for them as well. And then powers of attorney. Of course, your statutory durable power of attorney and your medical power of attorney. Having those together so that you've designated who you want to act on your behalf should you lose the ability to make those decisions for yourself. And then guardianship declarations. So who do you want handling your affairs if the guardianship is needed over you? And if you have minor children, who you want to handle being their guardian and take care of your children if you and your spouse are unable to do so.
And Pam, I think it's really important too to note here that so many people will call and they'll say, I need a will. I just need a will. My things are simple. That's all I need. When in fact, the powers of attorney are actually one of the most important documents that you need in your estate planning. So many times we are incapacitated prior to passing away, or we, get older and we need help handling finances and medical, making medical decisions. making appointments with our doctors, those type of things. Those powers of attorney are so important, and um, I think that's just something to really
Mhm.
note, that is a big part of the estate planning that people overlook.
Yeah, for sure. Thank you. Absolutely. And sometimes we'll get calls to the office saying, I need this power of attorney. I can't make decisions for my parents. And at that point, if they no longer have the ability to make those decisions for themselves, they can't sign a document that states that. And so it's too late to get those powers of attorney in place. And then what you're looking at is a guardianship over that person in court, which is very stressful for all involved, and expensive. Not only is it stressful, but you have to get an attorney involved. The court is going to appoint a second attorney to represent your parent, if that's who you're seeking a guardianship over. And then if it's a guardianship of the estate, then you have annual accounting that you have to hire an attorney to file with the court on your behalf as the guardian of the estate. And so you can see where these expenses would add up very quickly. And it's not a pleasant process. So yes, absolutely, powers of attorney are essential. And so how to plan for success with joint ownership in real property. So homestead, the home is generally titled as husband and wife. Even if it's not, if the house is purchased during the marriage, it's still, even if it's only in one spouse's name, it's still jointly owned by both spouses. So what's on the title is irrelevant. And so what are the tools? How can we plan, so that we make it easy for a surviving spouse to pass the surviving spouse to receive that house with as little stress as possible. So one option, like we talked about, is that revocable living trust. And this is that transfer deed. So you create a trust during the lifetime of both parties, and we transfer the house to the trust during your lifetime. At the same time, we set up the trust, or if we've already set up the trust and you purchase a new house, we transfer it at that time. And then when one spouse passes away, that house is still owned by the trust. And so the surviving spouse, at least for that house, doesn't have to go through the probate procedure to sell the house or refinance the house. I'm sure you see this a lot, Jessica. Oftentimes on the probate side, clients will come in and say, my husband passed away. I want to, I want to sell the house, and I have a contract on it. But now the title company is telling me I need to go through probate. What's going on? They don't even realize that they have to go through this procedure. And depending on the situation, it can be fairly easy, or it can be more involved, depending on the family situation and whether there's a will. So a revocable living trust can be a nice way to plan for the surviving spouse to have as much power as possible to be able to handle that easily after their spouse passes away. And so a revocable transfer on death deed is another way to handle it. It doesn't involve a trust. It's a deed that says, when I pass away, I want my interest in the house to go to this person. And so if it's a surviving spouse situation, generally it says to my spouse. And so then again, this is a non-probate means to do that. And there's some requirements that need to be met when handling either one of those. including the revocable transfer on death deed. There can be some title issues if you just use a form that you get off the internet. So I don't recommend doing that. And then planning with a will, after the death of either spouse, like we talked about, the homestead has to be probated in some way unless we use some sort of deed or a transfer deed with a trust. So that has to be done within 4 years, or that situation that Jessica talked about earlier, where you have to tell the court why you didn't probate the will within 4 years. And so even if your spouse had a will, if you didn't probate within 4 years and your spouse had children from a prior marriage, then you may still have to involve those children to be able to take control of the house that you live in and get them off the title to that. So that 4-year deadline is really important. Joint ownership in financial accounts. So the rights of the survivorship, we kind of talked about the downside, but there's a plus as well. You can use those rights of survivorship to pass property outside of probate to your surviving spouse so that it never enters the probate estate, right? So the situation where you have a joint account, both spouses are on it, but say you don't have rights of survivorship on the account. Well, technically, that account is now half owned by the estate and half owned by the surviving spouse. And while the surviving spouse still has access to it and can use those funds, if there are significant creditor and debt issues in the predeceased spouse's estate, then those assets are subject to those creditors. And so you may really want to use rights of survivorship to keep those assets outside of the probate estate. And you also want to be sure, even for your spouse, you need to have that statutory durable power of attorney so that you have the ability to conduct the financial affairs of your spouse prior to their death. So you don't automatically have that ability without that statutory durable power of attorney.
I think the biggest, takeaway from talking about, joint ownership and beneficiary designations, do your estate planning with an attorney, let them look at your accounts and what you have set up and help you create a roadmap as to what how are you going to designate the beneficiaries? How are you, what accounts should be joint? Should you maybe take a child off of an account and, list them in another role, right? So we want to be able to help you make sure that those designate. Did I switch?
Yeah, I don't know what happened.
Eddie called me and it switched it. All right, hold on, let me flip it. Okay, hold on. Stupid Eddie. Okay, which way am I? Which way am I up now?
Center it up now. So scoot the other way that I was telling you to earlier. Yeah.
Like that?
Yeah, I think that's pretty good.
Okay.
I just start from the beginning.
Okay. Should I start from the beginning of where I was or just start on Rev Trust? Or start on what is a will?
No, I mean, if you want to cover what you were doing. Here, let me take a drink first. I've been dying. Okay.
Okay. Ready? So I think the biggest takeaway from talking about beneficiary designations and joint ownership is, get with your attorney or contact us. Let us help you make sure that those designations meet your goals and that any joint accounts that need to be switched can be do can. Oh, okay, let's scratch that. I'm gonna start at Rev Trust or at Will. Okay.
I liked where you were going though.
You did? Okay, let me do it again. I'm just like,
But if you don't want to,
it's fine. I'll make it quick. Okay. So I think, oh my God. Okay. I think the biggest takeaway from talking about joint ownership and beneficiary designations is to, let us help you make sure that who you are listing in those roles aligns with your estate planning goals, and let us help you utilize those designations to your benefit. So let's talk about what a will is and what it actually controls at death. So a will is a legal document that directs the transfer of the maker's probate assets upon their death. So we've touched on this a little bit, but what is the difference between probate assets and non-probate assets? So remember, a financial account with a beneficiary will pass automatically to that person that's listed as the beneficiary. That account is not controlled by the will, and it passes outside of probate. So it's considered a non-probate asset. So even if you state in your will that you want, for example, your Chase bank account to pass to your children in equal shares, and then you only list one child on that Chase bank account, let's say, for example, who you want to be the executor of your will, you list that one child as the beneficiary. By law, that child has no obligation to share that money with any of their siblings. So it's very important to make sure that you have a properly drafted will and that you coordinate those beneficiary designations with your estate planning to make sure that your goals are met. It's also very important to make sure that you have a will in place so that young children or grandchildren do not inherit large sums of money at a young age. So we can set up stage distributions in your will where they receive limited amounts at different ages. And this can really serve as a good learning tool for them, right? So if we set up, for example, for them to receive 10% of assets at the age of 25, let's say they blow through that money. By the time they receive that second distribution, hopefully they've learned a lesson and they're smarter with the money the next time around. So, in your will, you can really set up provisions that protect your children, protect your grandchildren, and just make sure that the people that you leave behind have it easier to deal with your assets. Okay, let's talk about revocable living trusts. So I feel like revocable living trusts are becoming more popular. They're being talked about more. More couples are considering setting up trusts. At one time, and Pam, tell me if you think this is true, I think at one time revocable living trusts were considered something that only like wealthy people did, right? And now that's just not the case. So there are so many benefits to setting up a revocable living trust, and we will talk about those. So basically, a revocable living trust is just a legal document that contains instructions for what you want to happen to your assets after you pass away. But unlike a will, a living trust can also control your assets if you become incapacitated. So when you set up a trust, you transfer all of your assets from your name to the name of your trust. And then you control those assets during your lifetime, and you designate a successor trustee to control those assets after you pass away or if you become incapacitated. So legally, you no longer own the assets, the trust owns them. So when you pass away, if you have transferred all of your assets into a revocable living trust, then there are no assets for the probate court to control. And basically, you can avoid probate altogether if all of your assets have been transferred into a revocable living trust. So that's one of the big benefits of the revocable living trust is avoiding probate.
And I just want to add one thing there, Jessica, so that, why might you want to avoid probate? You probably get this a lot. A lot of my clients want to do it because they want the privacy offered with the revocable living trust. So if you have a will, any of those probate assets, if you have a will and there are creditors, or if you don't have a will, you're going to have to file an inventory of all of your probate assets with the court, and that is public record. And the will is filed for public record. So if you have provisions in there that you don't want people to see, maybe you're making larger provisions for one child over another, or you're making charitable gifts, or
you're disinheriting a child.
Yeah, all of that. And that's multiple reasons you want to trust in that situation. But yeah, if you just don't want that filed for public record, then you do that in a trust rather than the will. And so the will says, hey, I want to leave everything to my trust. So if it's needed, it's there. But the goal is that the trust makes all the distributions, and it doesn't have to be filed for public record anywhere. So that maintains that privacy.
So another benefit of the trust, in addition to, avoiding probate, like Pam talked about, the privacy, which is huge, we can also use the trust to control distributions to children. So earlier I was talking about, an 18-year-old inheriting a large amount of money, at one time and blowing through it. With the trust, we can set up those stage distributions. So, for example, they receive 10% at age 20, half the balance at 25, full balance by 30. And again, it can be that learning tool for the kids. And then, of course, using those beneficiary designations, instead of listing a minor child as a beneficiary on an account, we can list the revocable living trust as the beneficiary on the account. So that way the trust controls those distributions. And as we talked about, the children do not inherit at 18. And so some of the benefits. Go ahead, Pam.
You went away. Okay, and now you're.
Am I weird now?
Yeah. No, it's because now your portrait. There we go. I think just start at the setting up the different trusts within the trust. Do that part again, so we don't have to do the whole thing. Did someone call you?
No, it said like a battery thing. Okay. So, okay. So okay. So another benefit of a revocable living trust, in addition to being able to avoid probate, and like Pam talked about, the privacy issue, right? So making sure that the assets are kept private. We can use the trust to control distributions to the children. So we can avoid a child receiving a large amount of money at the age of 18. We can direct those financial accounts to transfer to your revocable living trust upon your passing. So instead of listing young children as the beneficiaries on an account, we can actually list your revocable living trust. And then that way, the trust provisions guide how those distributions are made to your children, and we can do them in stages and in percentages where if they blow through an amount, you know, it can be that learning tool that we talked about to where hopefully they become a little bit more responsible by the next distribution.
I want to add too, you can do some trust for your children's lifetime. So, so that, and perhaps you have a child that is completely responsible, but you're giving a large sum of money to them, and you want to make sure that at their death, it doesn't go to their spouse, but it goes to your grandchildren. Or you want to protect them and those trust assets from, their potential divorce from a spouse, so that you're protecting the assets that you left to them and it doesn't get split up in a divorce situation. So that's something else that, we do those within the revocable living trust. We can create those additional trusts for when you leave them to your children. And so those can be really valuable to making sure that your goals are accomplished.
That can also be beneficial too if you have a child that is frivolous with money or they have substance abuse issues. So if we're worried about, them blowing through money, we can set up a trust where they are provided for during their lifetime, and we can have a trustee control those funds and make sure that, that they're okay and they're taken care of.
Mm-hmm.
So overall, let's look at the benefits of a revocable living trust. We talked about incapacity. So if I have a client and I know they are going to be incapacitated in the future, I always set up a trust. The trustee can step in and provide for that person once they become incapacitated for the rest of their life without having to get the court involved, having to get a guardianship. It makes it easy for someone to provide for you if you are going to be incapacitated. There's immediate liquidity. So not only is this helpful if you become incapacitated and somebody needs to provide care for you, they have immediate access to the funds, but also if you have minor children. So if you have children and you become incapacitated, or you pass away and you have a revocable living trust set up, that successor trustee can step in and continue caring for your children so they can continue paying for daycare, medical costs, anything that
College
they need.
expenses.
They don't have to front any money out of their pocket. All of that money is there to take care of your children. If I have a client that has multiple properties and properties out in different states, so with a trust, you can put all of your assets into one place. So if you own multiple properties, let's say in Texas, if you have multiple oil and gas interests, trusts are great for that purpose. You can put all of those assets into the trust. They're in one place, and it makes it so much easier for the people that you leave behind to figure out what you owned and what you had. And if you have property out of state or in multiple states, we always recommend you set up a trust because you can actually transfer all those properties into your revocable living trust. So if you pass away and you own property in multiple states, you have to go through some type of probate procedure to clear the title to all of those properties. So you may have to probate in each state where that property sits. Obviously, we cannot help probate property that's in another state if it's an area of law or a state where we're not licensed. So you would have to hire an attorney in that state to help you clear that title. Whereas if you set up a revocable living trust, you can get an attorney to just draft a simple deed for each property, wherever that property lies, transfer it into your trust, and everything's in one place. The privacy that Pam talked about, this is huge. So filing that inventory with the court when you have a will, with the trust, you don't have to do that. People do not know what you own. They don't know what your beneficiaries own. And then, of course, avoiding will contests. If you avoid probate altogether, there's no worry about having to, I messed up. Okay. Dang, that was a bad place to mess up.
I think you should just start at there's no worry. Yeah.
I don't even know where I was. Okay. I don't need to cover the multiple property thing.
No, I don't think you need to cover the privacy thing. Just start at the avoid will contest.
Okay. One of the other benefits of a revocable living trust is avoiding a will contest. Of course, if you do not have to go through a probate procedure, there's nobody. Why am I? Okay, I'm just going to skip that. Okay, ready? One of the other benefits of a revocable living trust, of course, is avoiding probate altogether. And then within that, avoiding a will contest. So if you are providing for beneficiaries in a way that may cause someone to get upset or want to contest a will, if you distribute through a revocable living trust, that option's not available for them. So there are lots of good reasons to set up a revocable living trust, and we can help you talk you through those scenarios. So let's look at an example. So we created a revocable living trust for Samantha and her husband. All assets were transferred to the trust, including their home. And then when Samantha's husband passed away, she was able to sell the house that they lived in immediately after he passed without the necessity to probate the will. And then when Samantha passed away, Samantha's daughter was able to sell the house and distribute the assets to Samantha's children without the necessity of probate. So avoiding probate by setting up a revocable living trust is a huge benefit among many other benefits like we talked about.
Absolutely. All right. So, how to plan for success. What is a power of attorney? So I've referenced this a few times, but a statutory durable power of attorney is a document that can authorize another person to make financial and legal decisions on your behalf. So in your statutory durable power of attorney, you can say who you want to act on your behalf, and you can, and we recommend naming backup so that if that first person can't or won't act, then who else can act on your behalf? Because again, having this document in place is extraordinarily important so that someone has that ability without the need of going to court to prove that you are incapacitated and that a guardianship is necessary. And then the medical power of attorney with HIPAA release, again, authorizing that third party to make medical decisions on your behalf when you can't do so for yourself. And then the HIPAA release, authorizing that person to access medical records, speak with your physicians so they can make informed decisions about your medical care with your physician.
I just want to point out one thing quickly. Sorry, Pam. I just want to point out one thing quickly here. A lot of people come in and say they don't need this document because the hospital has already had them sign one. Please keep in mind that the document that they do have you sign is the standard form, and the documents that we draft in our office are a lot more thorough. They contain a lot more of other decisions that you make in addition to the ones that you will be just filling out quickly at a hospital stay. I don't know if you want to touch on that more, Pam.
Yeah, an example is, organ donation. Do you want your organ donation, your organs donated, or do you specifically not want that? People generally have pretty clear vision on whether they want that, and so we incorporate that into your medical power of attorney. Some people don't, and we don't have to include that, but that's just an example of something that is not going to be in your standard form that you find with the hospital or an online document.
That's a good example.
And along with that is your directive to physicians. This is, of course, what's commonly known as your living will. This is where you can decide that, yes, I've given my agent power to make decisions, medical decisions on my behalf when I can't, but I'm going to make some decisions for myself now. And so those are, do I want life-sustaining treatment if I have a terminal or irreversible condition? So you can decide now that, no, I don't keep me alive artificially. I want to be kept comfortable, but don't keep me alive artificially. And then, of course, we touched on the declaration of guardian for your children. Within that document, we're also going to designate temporary guardians. So if your permanent guardian is not available to take immediate possession of your children, who do you want to take immediate possession? Perhaps your permanent guardian is coming from overseas or another state, and they need time to get there. Then you want someone that your kids are familiar with, that you trust, to take that immediate possession until your permanent guardian arrives. And then the appointment for disposition of remains. This is where we can, of course, designate an agent to make your decisions regarding your funeral and burial versus cremation, those kinds of decisions. And perhaps what you want, and so we can be a little more specific there. And then, of course, we touched on the revocable transfer on death deed or ladybird deed, and how that can be incorporated into your overall plan. And we didn't touch on this that much, but these can be utilized in some Medicaid asset protection planning. Making sure that you can qualify for some sort of long-term nursing home care and still pass your assets along to your loved ones. So, that's too big of a topic to touch on here, but, just know that that planning is important as well. So, where do we go from here? We've given you a lot of information. I hope everyone's found it useful. Your offer for completing, sitting through this, and hopefully learning a lot of information is to go ahead and book your free 1-hour family goal setting session with us. If you do so within a week, that will be free. And we can look at what plan do you have in place right now. If you have no plan, how would that play out with the state of Texas plan? What does that look like for you and your family? We can talk about what family values, what keeps you up at night, what worries you, and what's most important to you, and how can we help solve that? This, of course, is only available to those that watch this webinar. There's no obligation to hire, and we can review any existing plan that you have. And so that this is kind of our estate planning process. You come in for the family goal setting session. Once you hire us, then we'll deliver those estate planning drafts to you via email generally. And then once you look those over, a week out, we're going to schedule a phone call or an in-person meeting or a Zoom to discuss those drafts with you and review any questions that you have. And then we schedule that signing meeting. So generally speaking, this whole plan can be put in place in a 4 to 6 week timeline. And so, it's not something that is a long drawn out process. Through our process, we can get your plan in place within, a fairly short amount of time, and hopefully set your mind at ease. And so, thank you for sitting with us and getting all of this useful information. We hope you found it useful. You took the time. I highly recommend, booking a time with us, because, there's a reason you watched this and spent the time to do it. Take that momentum, book your session with us and can work through your plan, so you can get all of your concerns addressed. Jessica, do you have anything to add?
I think that sums it up. Just, like Pam said, you've taken the time to sit through this, and it's obviously something that's on your mind and important to you, and just, reach out. There's no cost to you to talk with us and pick our brains about what you need to do to just make sure that your loved ones are taken care of and provided for.
Yeah. And if you have any questions, you can send an email to that info at Hailey-Petty Law down in the corner. And then Lisa can get with you on getting that answer or getting you booked for that meeting with us. So again, hope you found it useful. Thanks so much for taking the time, and hopefully we will talk with you soon.